Hello. Hello. Hello.
Hello.
Yes. Hi, Maruk.
Hi.
So Kaushik is also there. Hi, Kaushik.
Hi,
Hi,
Shraddha.
Sandhu. Kaushik, you're on mute.
Can you hear me now? Mark?
Yes.
Mr. Verma is there. Good afternoon, Mr. Verma.
Good afternoon. Good afternoon.
Good afternoon. Good afternoon. Great to see you. Great to see you. Thanks, Book. Marut, are we good to start if everybody's there?
Yes, please. Yes,
Yeah.
everybody's there. So let us
We are
start.
live.
please.
Yeah, yeah. So, Mr. Secretary, with your permission, if we can start the proceedings of the session, please.
Yes, please.
Yeah, thank you. Thank you. Thank you. And good afternoon, everybody, and a very warm welcome to this special plenary session that we have with the Secretary, Ministry of Corporate Affairs, Mr. Rajesh Verma. May I start by welcoming Mr. Rajesh Verma, Secretary, Ministry of Corporate Affairs, to this very important and a very, very critical session of a national conference on what we have chosen as a topic, 5 years of IBC, 2016 and way forward. And Mr. Verma, just to mention to you, we have with us in this session Mr. Shardul Shroff, the Executive Chairman of Shardul Amarchand Mangaldas, and also Mr. Kaushik Chatterjee. Kaushik is the Executive Director and CFO, as you know, of Tata Steel, and he has been leading CII's work as the Chairman of the CII's National Committee for CFOs. And so great to have Kaushik also on board. So, ladies and gentlemen, it's really a great privilege to have as our chief guest Mr. Rajesh Verma, the Secretary, Ministry of Corporate Affairs, Government of India, at this plenary session, as I mentioned, of a very important national conference which we are having over the course of the day today. As we are all very well known that, if I can say, Mr. Verma is really the chief architect of the IBC 2.0 that shall be driving the growth momentum as we see of the Indian economy in very much of what we say the dynamic times that we are in today. And from the Indian industry, I would like to really say thanks to Mr. Verma for your very visionary leadership during the unprecedented times that we have had because of COVID, and a slew of measures we have seen being introduced by the MCA to ensure continuity of operations, and if we can really say, the business community really looks forward to the revamped insolvency framework as we are emerging from the impact of the pandemic. At this particular session, Mr. Secretary, we have more than 300 odd participants from across the country who have joined us through our digital platform. And as a special, this is the effort, we see that some of the best minds of the corporate world are really present today. I would also like to inform you that prior to this session, we had three very important sessions which deliberated on a range of topics related to IBC 2016. And as we all know, the government of India has made persistent efforts in the last few years for simplification and ratification of existing rules and introduction of IT to make governance more efficient. And thanks to the efforts of the government, India's performance in EODB, the ease of doing business, has indeed significantly improved, and we all appreciate that. And This is, of course, well reflected in India's attainment of the position that we are in today, 63 in the world latest doing business report of the World Bank. Some of the very important and extraordinary steps that one has seen being taken in the last few years. And we are only, if I could say, stone's throw away from being amongst the top 25 doing business nations, as has been the vision of our Honorable Prime Minister. At CII, we have been working very closely with the government as well as many state governments in improving our performance in performance in doing business report as well as at a pan India level. And we have a task force which is called the CIS Task Force on Ease of Doing Business, which is working in more than 10 areas of ease of doing business. And resolving insolvency is one of those very important areas. And the sharp movement, if one sees in the ranking, I would say it's largely attributed to the landmark initiatives that have been undertaken in the domain of resolving insolvency. And where India today, we stand somewhere currently at about a very good position, actually 52nd out of the 190 economies, as compared to our rank, which was 136 in 2016. So I would say that the government's really bold decision to introduce the IBC 2016 has not only facilitated the increase in rankings, but also redefined the way insolvency proceedings and restructuring are perceived amongst industry. And as IBC 2016, today we are completing 5 years of implementation. It has also provided a very well-defined and, if I can say, hassle-free resolution mechanism for dealing with the rising levels of distressed debts in our country. And the code has also actually helped in streamlining complicated and conflicting laws and creating a unified resolution framework that addresses the gaps and inconsistency in the previous versions. And I'd like to really also mention about and share that as per the recent statistics from the IBBI, ever since the provisions relating to the corporate insolvency resolution process, I'm talking about the CIRP, came into force in December 2016, we have a total of 4376 CIRPs that have commenced by the end of March 2020 to 2021, and of these, approximately above 60%, that is as I see, it's written as 2653 cases that have been closed, and the average time to resolve the insolvency reduced from 4.3 years as a time-bound, cost-effective resolution process, and really is providing a greater clarity on matters of corporate restructuring and roles of various stakeholders in resolution process. And as a nation, as we have really gone through the COVID-19 crisis, the contours of the code were being consistently, one can say, evolved for the creation of a more sort of a robust and a stronger insolvency regime in very critical times. And some of the reform measures which were greatly appreciated by the industry, that really includes things like the increase in the threshold amount of the default required to initiate an insolvency proceedings from 1 lakh to 1 crore. And it helped really several of our MSMEs from being pushed into insolvency for their inability to meet their repayment obligations, which were caused, of course, by the business disruptions. But further, if you really look at the promulgation of the Insolvency and Bankruptcy Code, the Amendment Ordinance 2020, which suspended initiation of insolvency proceedings against corporate debtors in respect of any default arising during the period of the pandemic, that also provided great relief to all our businesses. And while these measures, along with a gamut of other reforms initiatives, have helped the businesses sail through the unprecedented tough times, it is now really crucial for us to focus on the evolution of the insolvency system, stabilization of the processes, and promote growth for jurisprudence that shall really help in enhancing the effectiveness of the IBC 2016. So the larger objective would be to enhance availability of credit balance interests of stakeholders and promote entrepreneurship. I'd like to really also mention that, IBC 2016 is really not the magic wand, if one can say, that can provide solutions to all sorts of problems at once. And it is important for us here to mention that the transition to IBC 2.0 does entail some bottlenecks, and there have been haircuts of up to 95%, as we know, during the resolution process, and there are over 13,000 IBC cases involving uh, around 9 lakh crore rupees pending before the NCLT, out of which easily 71% odd have been pending for more than 180 days. And these facts are really indicative of the need to make the process under the code much more efficient. And we strongly believe that the government has been working so very proactively on identifying more such issues which face in the code over the years. In the recent Standing Committee on Finance, chaired by Mr. Jayant Sinha, on the subject of implementation of insolvency and bankruptcy code pitfalls and solutions, so that's really provided several recommendations to strengthen the implementation of the code. And we would like to really commend you, Mr. Verma, as these measures really reflect the commitment of the government in making exit of business much less painful and much less complex for the stakeholders as we prepare for IBC 2.0. We have some very, very strong, good experts also in this field who are here, and I could have given some behind CI to put up to you, but I shall really put them up to you when we talk separately, or when I am able to put up a note to you. But I must just wanted to conclude by saying that we have been from CII been active in giving suggestions to stakeholders for improving insolvency resolutions in the country. And as a part of that, we have prepared a comprehensive report on cross-border and personal insolvency in India, a roadmap for implementation. And we've created awareness amongst stakeholders by organizing some outreaches and training workshops in Delhi and also in Bombay, and taking forward the initiative. This particular national conference, which I spoke about, that started today morning, was successful really in deliberating on the expectations that the business have from IBC 2.0. Additional issues arising out of COVID-19, such as things like deterioration in values of companies, preference for liquidation rather than restructuring, tackling bankruptcy proceedings of real estate and construction, and lack of adherence to the deadlines. So I'd like to really thank you once again and welcome you, Mr. Verma. I'd like to state that CII will remain committed to the developing of a robust roadmap for IBC 2.0, which will help the country emerge as one of the favorite investment destinations for the world. And once again, would like to thank you and welcome you for being a part of this session. Thank you once again. With that, I'd like to request Mr. Shardul Shroff, who is the chairman of CII's Task Force on Insolvency and Bankruptcy Code, and of course chairs the Shardul Amarchand Mangaldas, and to speak on IBC 2016, progress and way forward. Shardul.
Thank you, Chandrajit. Thank you, sir. It's been a pleasure serving on many of your committees. And I just wanted to summarize what I believe should be the future in terms of remodeling some of our suggestions and working to move the code into its next 5-year perspective, if I may use the word. So if you see the history of the evolution of the code, I think the code really triggered well once the Reserve Bank of India had identified the dirty dozen and effectively put their actions of resolution in motion. In reducing the doubts and really came forth with a robust way forward, because it dealt with questions of Section 29A, it dealt with questions of Binami bidders, it dealt with questions as to what should be the decision-making process of how the CRP and the resolution plan should work, how they should be approved, and similar. It's a very vastly, it reaches very vast, and it covers a lot of issues. Before that, of course, there were two previous judgments where in the innovative industries case versus ICICI Bank and Swiss Ribbons versus Union of India, the constitutional validity of the IBC was tested, and the Supreme Court upheld the validity of the law and therefore permitted its progress. The objective of following the top-down approach was to really test the law and its constitutionality rather than reaching it from the bottom-up approach. And I think that has of how the IBC in can be. It also decided, so the industry's case, it also decided that the code is a complete code in itself and exhaustive in the matters dealt with it. So where there was a contrast between the Maharashtra Relief Undertaking Special Provisions Act and the court clearly held that the code prevails because it is a later legislation and it is part of the concurrent list. So it would prevail over prior laws. This the 12 largest disputes or arrears of bank loans and were something which it was like 1/4 of the total debt of the banking system in these 12 cases itself. And resolve frame was very critical because it took well for the economy that the bankers had actually brought back to book the monies which were really in suspense or not being employed gainfully. This aspect saw one more interesting phenomenon in competition, in that for the real estate, for the real economy, where you speak of cement, steel, and products which are of short supply, which depend upon rare materials or raw materials which are not freely available, which are licensed, and which require a different approach when one considers the ability of freely moving into alternates and freely substituting the products. That like an open Binani cement, where though the fact that Binani cement was, the bidder was hopelessly out of time, the Supreme Court gave to bid till the last day, and a really positive outcome, more than the outstandings of the bankers and the workers and the operational creditors. Money was received in excess of that, which is one of the rarest cases that we have seen so far in the IBC. So you've seen that, but it's not a general statement. I don't think the general proposition that there is enough competition. Law has been premised on the basis of competing requests or competing bids, that the law has effectively found remedies because competition itself has disappeared. With the COVID phenomenon that came about, one of the fundamental tenets of the IBC, namely that any product which is effectively in the resolution phase can be bid out, and the bidders would effectively discover the right price for the product, which was otherwise struggling by virtue of the previous management, or for whatever reasons that there were. Better management could step in, better resource management could work, and this was a principle, or this is the principle on which the IBC works. But with COVID coming in and one seeing the suspension of the law, the acceptance by the government and the industry that there is inadequate demand is inevitable. That's the only logical conclusion that one can reach, that the law needed to be suspended because there was no countervening demand. And in the absence of a demand, the discovery of price would not work effectively. So this, in a sense, justified the deferral of the applicability of the IBC during the 2 years that, or 1.5 years that COVID was effectively rampant in India. The second phase, which we saw after the first phase of the dirty dozen, as it is known, is that the Supreme Court confirmed, in the absence of any other criteria given in the Act, that the decision of the creditors was, and their business decision was relevant in this process. I remember when the Sikh Industrial Companies Act was promulgated, and the then Finance Minister, Mr. VP Singh, had spoken on the floor of the House. He had clearly indicated that a company whose net worth is eroded is really running on creditors' funds, and the promoters' funds are effectively wiped out, and therefore the right to decide on the action of reviving a company is actually in the lobby of the committee of creditors. And this logic prevails, creditors, which has been given the sanctity of having its resolution plan approved by majority as prescribed, go through as a resolution plan approved by the NCLT. So the logic is no different, that you have let the company down, though no longer the principles of net worth and those principles which are embodied in the Sikh Industrial Companies Act don't find presence in the IBC. Different criteria are applied, which is basically a default-based law. And therefore, you have a structure which is very different from the Sikh Industrial Companies Act, but it is based on that the creditors have the maximum say, because it is the creditors' money which is at stake, and the promoters' money is effectively totally eroded. And that is why there is the need to give the primacy of the creditors' decisions under the IBC. Perhaps the SR Steel case is the largest successful case in the history of IBC administration, both judicially and in terms of administration by the IBBI and other banking RBI principles which are applicable in revival, as also restructuring of debt. So it is one of those cases where both objectives, namely restructuring of debt, revival of the company, and avoiding insolvency, all three objectives were met by this particular classic case under Indian law. Previously, in the K. Shashidhar's case, the Supreme Court had identified that the business principles, the principles of taking a view on the basis of what they believe is the right course of business, the bankers and the creditors, the financial creditors, would have the say, as long as they have the appropriate majority. Now, there is a slight disturbance in this space, as the recent Finance Committee, led by Mr. Jayant Sinha, has now proposed a code of conduct for professionals. My own personal view is that a code of conduct for a committee of creditors is impossible, for the reason that the code, if any, over any intermediary or any authority has to be administered by the licensor. And the licensor in the case of banking institutes or other financial creditors is the Reserve Bank of India and not the IBBI. It is not even the SEBI, because partially whilst capital raising is regulated by the SEBI, the ultimate regulator for the Committee of Creditors is the Reserve Bank of India. And it is the Reserve Bank of India which audits the bankers. It's the Reserve Bank of India which functions as the agency regulating the banks and seeing whether they are functioning in accordance with the norms that have been prescribed to them in the RBI Act and the relevant regulations. So there is already a space which has been filled up, namely by the RBI and the RBI regulations. And to then say that there will be a code of conduct coming through the IBC is a complete sort of mismatch in the sense that these two cannot be reconciled. It is usually when the licensor has subjected or submitted himself to an adjudicate to a regulatory body that the question of a code of conduct arises. If you see the SEBI law, the brokers, all the relevant intermediaries are subject to licensing requirements by SEBI, and SEBI therefore has a power of passing codes which are part of the statute or part of the regulations, and then emphasizing how one's conduct should be. In parallel, therefore, if we were to perform a similar operation under in the IBC, it would require a slightly different treatment in that it should not be a code which should be instituted, but it should be the amendments to the functions of the Committee of Creditors which should be instituted. And part of the functions will really require what needs to be controlled. It is impossible for one to say that in an industry which is obsolete, in which there are far many more competitors than the way one started out with, it is a situation where conglomerate, and therefore there are settled at 2,000 crores or less is not the correct view, because there are far more industries of the company concerned, Videocon, which manage oil assets and other assets outside, for which the debt was truly taken and for which the sale as a going concern will fetch value. So to state that that should be a behavioral issue, or that it should be an issue which should be looked after in the national and the larger interests of the community, is something which is relative. If one looks at it from the perspective of competing consumer products or competing technology or competing obsolescence which has stepped in, then perhaps these issues may not be highlighted in the manner they have currently been. So this is one feeling I had arising out of the Jayant Sinha report that needs to be relooked at. The other issue which in my view is sort of imminent and will require reconsideration is the cross-border insolvency. So now in the cross-border insolvency, it is basically a company and its branches, and not the company and its holding company and subsidiary which are really involved. So if you're looking at a group approach, or if you're looking at a cross-border approach, unless you marry the concept of a group and a cross-border insolvency, you are not going to resolve much. Because the way industry has been set up, industry does not now set up branches as much as it sets up special subsidiaries and special holding companies. So to say that this will have a far-reaching effect as a cross-border insolvency program, I personally am skeptical that it really resolve the kind of modern industrial problems and the modern insolvency problems that arise from time to time. We need to look at the concept from the perspective of a group conglomerate, and how in a cross-border insolvency situation, you bring all the companies which are simple majority held by a particular group under one umbrella. And that will naturally be the umbrella where the country of origin is. and then see the corresponding debts outside India. The salient feature under the IBC is that the IBC permits foreign debt to make a claim, and therefore it is not as if the foreigner has no remedy. The foreign lender has remedy, and one of the basic issues, therefore, of cross-border insolvency is met even under the current IBC without introducing the cross-border insolvency provisions. And this is something which we should significantly note. Why has there not been a great demand for group insolvency or for that matter, cross-border insolvency? Because the foreign creditors are allowed to be present in India, are allowed to have their say, are allowed to decide what is the value of their debt. But in relation to the group or in relation to where there is a cross-holding of security, there the concept of cross-holding, whether it is under our law or whether it is under the foreign laws, which will be applied equivalently, this solution is not going to be simple. And if one expects that the cross-border insolvency in its present form, as per the present report, is going to solve much, I have, personally speaking, my doubts as to whether it'll address the modernity of insolvency law and the modernity of how corporates are organized. So also in the context of group. Firstly, in the context of a group and cross-border insolvency, it requires a completely virtual proceeding. You have to have the hearing simultaneous. It effectively becomes like a division bench on the original side. Because whilst the Indian side, Indian adjudicators, namely the NCLT, will look into questions of insolvency as far as the Indian resident company or the Indian assets are involved. The foreign assets of that company lying abroad in the form of a branch asset will need to be looked at from the perspective of the foreign law, by virtue of the fact that you have joined into the Treaty of Cross-Border Insolvency. There are some 43 countries only, not the whole universe of much larger corporate, business countries that we work with. And therefore, whether this will have large applicability is also one of the perspectives that we need to look at. Therefore, when you look at a simultaneous proceeding, you must have an say, for example, if Japan and New Americas were resolving matters, then do we have to set up a common law which will regulate disputes of both countries? It's possible today to have a party autonomy and therefore to select contract law. One can say, I will apply the Singaporean law. One can say, I will apply the procedural law of England. So there are all these, or for that matter, even the substantive law of different countries. Whereas in the IBC, you don't look at all these issues. You look at the simple fact, and you look at the fact that that default has not been paid on due date, and you go ahead with the proposition that because it's a defaulting company, it needs revival, it needs refocus, and it needs to be put back on rail. So these are some of the issues I believe need to be real in the context of the reports that have been already prepared by the Ministry of Company Affairs through its various committees. Lastly, in the context of pre-pack, I feel, I was a party to the whole report, but the feedback that one is getting is that it is little too complex for the kind of industry to whom it is addressed. And that is the reason why you have not got much traction in relation to the pre-pack part of the law. But this will also change in that there is a great demand just now for the larger industry asking for pre-packs. Whilst deliberating, we decided that we should have some track record and some experience before we open this to many other higher sized industries. That is not happening. Whereas the demand for a cross-border, for a prepackaged resolution is still very high and very active in the minds of the corporates who are looking for relief. And the last point which I want to urge is, sir, is that whilst the Supreme Court has actually talked about a clean slate, the approach from the governmental authorities and the tax authorities especially is to press after the insolvency is over and after the resolution plan is over for their dues. Now, this is absolutely contemptuous in many ways for the reason that the Act contemplates that the government is an operational creditor. It is sixth in the queue, fifth or sixth in the queue as defined under the Act. It has a right to make its claims before the resolution professional. Nobody has stopped any authority from lodging its claim before the resolution professional. The government in its statutory bodies or in statutory dues does not do so. And then once the resolution plans are finalized and the extent of the operational creditors are decided, because the operational creditors only get 10 to 20% in the rupee. So if at all, they would get a very insignificant portion of the dues or the distributions in an insolvency. Yet they are trying to hold up the entire resolution plan by reason of notices, by reason of issuing summons, and the whole procedure then ceases to be a clean slate. The objective with the Supreme Court has explained, and what the law itself explains is that you have to come out with a clean slate. Because otherwise, if you approach it with the way that the government departments are approaching it, there is no clean slate and there is no end to the resolution plan. If after the resolution plan is approved by the NCLT, you're still going to entertain disputes pre-resolution plan, then you have not achieved the kind of insolvency resolution that was contemplated by the IBC. And if this is scrutinized deeply by the World Bank or World Bank authorities, they will push us way behind in the ranking of ease of doing business. That whilst this company has on paper, whilst this country has on paper a robust law on insolvency, in practice, it is exactly the opposite. And this is something which can be fixed. There is no rocket science as to how this can be fixed. And it is that fixing that one needs to do in the context of how the law should progress. And this is one of my most earnest requests, whilst the additions and all the other aspects of digitization and all have been spoken in the beginning of the sessions today. Nobody has really spoken about how to get the clean slate approach done post-sanction of the scheme. You have problems, therefore, which arise in relation to the remuneration of the resolution professional. You have problems which arise with reference to the COC post-closing. Because if suddenly the unsecured creditors or operational creditors come into the fray and are asking priority over the secured creditor, the whole resolution plan is unsettled. So these are some of the aspects which I thought are salient aspects in discussing the way forward on the version 2 of IBC. And I'll be very happy to have discussions because we regularly meet as a committee and help the government progress its thoughts in some different ways. Thank you so much.
Thank you, Shardul, for that very detailed presentation that you have done on IBC 2016. Thank you very much. May I now move to our next speaker, who is Mr. Kaushik Chatterjee, and Kaushik would be giving the industry perspective of this. So, Kaushik, may I request you, please?
Thank you, CB. Good afternoon, Mr. Verma, and all those who are listening in. Thank you to CII for inviting me to talk on this subject. After Shardul's detailed comments, I don't think I have much to say except that I will possibly echo some of his comments. To start with, I think every major economy in the world have a structured insolvency management process, and we possibly started late out of a crisis in 2016, but it is also important to mention that it was significantly robust legislative process, and the changes that happened soon after the enactment due to the proactive stance of the government, the MCA in particular, as well as IBBI was remarkable. We have been as Tata Steel an early participant. We have so far participated and been successful in about 3 of the resolution plans. And our experience has been that in the initial years, especially when Bhushan Steel was on the resolution process, there were a lot of changes that the government brought in based on practical feedbacks that came from us and the rest of the industry. Because, as Shardul mentioned about the dirty dozen, and that was the period when a lot of amendments, clarifications were put in place. Normally, a resolution process or an insolvency process in other countries starts with small applicants, but in India we started with the big 12, and I think that also helped in ensuring that the complexity is rightly addressed. So I think we have had a great journey so far. There are a few points that I would like to mention, that the IBC certainly helped in not only being a transparent process, but also helped in the price discovery, which was done in a certain methodical way. Yes, in the initial period, there were questions whether it will be multi bids or single bids, etc. But finally, it got resolved into it. And more importantly, it helps sustain businesses, the underlying businesses, preserves the employment of the employees, and also helps the direct and indirect effect on the economy around which, for example, manufacturing operations of the resolution applicant is. So, in summary, those were certainly the good part of the experience. Going forward and looking at our experience in the last 5 years, I would just mention a couple of points which can be considered in the second version of the IBC. And the first one is the timeline. The timeline to close from the date when the COC declares a successful resolution plan to the closure of the plan and handover to the new owner. While there has been the 180 days and 270 days kind of timelines in the Act, but it needs to get implemented much faster, because it's a question of preservation of value. It's a preservation of the whole integrity of the process. And we see that more often than not, the defaulting shareholders would tend to litigate. What they get out of it is essentially to drag on the time to hand over the, or not the handover, but even eventually the process to get closed. And there needs to be some form of, and I can also say that the different courts of the country have ruled in the way in which it needs to be more tightly done, but some kind of legislative positioning on this would be helpful to ensure that frivolous litigations are avoided once the NCLT has endorsed the plan, or once the COC has declared the successful resolution applicant. So I think that is an important part, because unless that happens, we will have very long duration processes, and the cycle time effectively will remain a challenge. It is also a time that every day lost is not only value lost for the resolution, the successful resolution applicant, but it is also for the creditors, and there is a time value of money. The second part of it, which Shardul alluded to, is the post the resolution. We see that there are often regulatory bodies which puts the demand on past liabilities, and it is typically at the state level, because Initially it was at the central levels, but now I think we see more of the state levels, because the states often say we are not party to the process and therefore these are due. So a kind of appreciation at the state levels to understand this process would be helpful. And I had had conversations with many resolution professionals who also face the same issues in handling before the handover is done. So I think if this point can also be addressed during the process of the revising or revamping of the IBC in the second phase. The third one is the whole concept of pre-pack and how do we get that process in place. Actually, the pre-pack for large companies is also as important as small companies, and it will possibly help the companies in getting resolved the insolvency issues resolved faster. Uh, Typically, I have seen in the West, in more particularly in the UK, where the going concern assessment is done by the boards, and it is obligatory on the boards of the companies to do that assessment. And if they feel that the going concern test is not being robust, they actually bring in their version of resolution professional or administrators early enough and early into the process so that it can be tested out whether it needs to go through a pre-pack or it needs to go through a full resolution process. So it may be worthwhile to look at the regulatory framework holistically and see if the early warning indicators can help in the initiation of pre-pack and involve pre-pack on a larger scale, not just one size of corporations. This I think will help again in capital efficiency across the system and will ensure that the sustenance of the company or the underlying business is continued. The last 2 points from my side is during the resolution process for listed entities, we keep seeing that the shares continue to be traded. And if you really look at a company which is going through an insolvency process, would typically have a negative equity by definition. So therefore, the continuing to trade that security in the exchange only creates speculation. It is speculating against the resolution will be done and people will create value out of it. So in kind of a best practice, when a company is admitted into the resolution process, the shares of listed companies are typically suspended. On the resolutions being completed, it is again allowed to trade. So this will help in the speculative part of the equity side to be taken out, and the value being more on the underlying side. This has been talked many times, but I thought it was important to mention. And finally, going forward, it may be worthwhile to also explore whether one can get into online auction as a part of the value discovery process rather than just one bid, one closed bid process. There will be even better market discovery if one goes through the digital platform and conduct online valuation discovery. So with that, I will end my comments. Thank you very much.
Thank you very much, Kaushik. Thanks for that very succinct exposition. Very brief, yet very well said on the industries from the industry side. With that, it's now my pleasure and honor to invite and request our chief guest, Mr. Rajesh Verma, the Secretary, Ministry of Corporate Affairs, to give his address, please.
Thank you, Mr. Chandrajit Banerjee, for inviting me to this conference on the very important topic of 5 years of IBC 2016 and way forward. Mr. Shardul Shroff has spoken, Mr. Kaushik Chatterjee has spoken. I was keenly listening to them and also will be keenly looking forward to the report from this conference, which you said you would be sharing with us so that we can have better perspective of the whole event. We have been discussing. Of course, Mr. Shroff is there in the committee, Insolvency Law Committee. Many issues we have discussed, and we are still continuing to discuss. In fact, recently we have, I think, in one of those forums, you were also there, CIA was also there. We had very recently a discussion at the level of Chief Economic Advisor, myself, IBBI, we had organized. In fact, yesterday also we had some consultation with the stakeholders. Every week, we are having this constant interaction with the stakeholders because many issues have cropped up. Some of the issues which have been pointed out today by the two, in fact, the three speakers, all three of you, have also been discussed in those forums. Our consultations are still continuing. We'll continue to engage with the stakeholders and for reimagining the IBC at this critical juncture of its 5 years of existence. Ease of exit, as we know, is as important as ease of entry for a business. In fact, before enactment of IBC, Indian businesses did not have the freedom of exit and also to resolve the insolvency so easily. The resources, once stuck in the unproductive enterprises, they continued to do so in the insolvency framework, as the framework was fragmented, inadequate, and was quite ineffective. But with the will to revamp these archaic laws, which have been pointed out, SICA and that IFR days, and with the vision to build New India, led to this innovative initiative of Insolvency and Bankruptcy Code, which has really transformed the Indian insolvency framework. As we all know, this IBC framework was enacted to consolidate and amend the laws relating to reorganization and insolvency resolution of debtors in a time-bound manner, basically for maximization of value of assets of such persons, to promote entrepreneurship, availability of credit, and above all, to balance the interest of all the stakeholders. It was a landmark legislation in India's history of economic reform. Its once nascent story has now transformed into a very efficient, effective, and preferred legislative framework to deal with insolvency resolution of the debtors. This landmark legislation has got well-deserving recognition and appreciation from the judiciary. As was quoted also, and Honorable Supreme Court in the Swiss Ribbons case had very aptly summarized the whole framework by saying that the defaulter's paradise is lost, and in its place, the economy's rightful position has been regained. The code has improved the business environment. It has elevated the distressed assets. Till July this year, in fact, more than 4,570 cases were admitted for corporate insolvency resolution process, the CRP. Out of this, 657 cases have been closed on various grounds of appeal, review, settled. 466 cases have been withdrawn. 404 cases have resulted in resolution, and 1371 cases have resulted in liquidation. These 404 cases which have been resolved have realizable amount of more than 2.5 lakh crores. In addition to this, 17,837 cases, you'll be surprised, involving an amount of more than almost 5.5 lakh crores, they have been disposed of at pre-admission stage. That is the strength of IBC. That is the change in behavior which IBC has actually achieved. It has been also, the code has been one of the enablers in improving India's rank in World Bank Ease of Doing Business report consistently, as was stated by Mr. Chandrajit Banerjee also, that we have jumped almost 84 places in last 3 years, from 136 rank in 2017 to 52 rank in 2020. The recovery rate also increased from 26% in 2017 to 71.6% in 2020. The time taken in recovery also improved from 4.3 years in 2017 to 1.6 years in 2020. Government has been also proactively monitoring the developments in this insolvency framework and has brought out timely reforms. In fact, till date, code has undergone 6 amendments last 5 years, and that has strengthened the framework and removed various bottlenecks. The outbreak of COVID-19 pandemic, it caused unprecedented challenges to businesses. And in fact, it has forced the governments around the globe to rethink about their response to tide over the crisis. Combat these challenges and to also ameliorate the stress, the government of India also took several steps. Like one of the speakers was mentioning, the threshold for initiating insolvency proceeding was increased from 1 lakh to rupees 1 crore. Like that is the maximum permissible limit under the IBC. The initiation of the provisions of IBC were temporarily suspended from 25th March to 2020 to 24th March 2021, 1 full year, so that the companies which are otherwise viable are not pushed into insolvency. The pre-pack resolution process, which all the 3 previous speakers have spoken about, that was inserted by the IBC Amendment Act 2021 recently for urgently addressing the distress faced by the MSME corporate debtors. This provides a much quicker, cost-effective and value-maximizing resolution for all the stakeholders in a manner that is least disruptive to their businesses, and it also ensures job preservation. We are aware about the demand being made at various forums, in fact, for extending this pre-pack to the larger corporates. IBC is an evolving legislation, as we have seen. The issues and challenges that often crop up, it's basically value erosion, conduct of the committee of creditors, even insolvency professionals, delays happening in NCLT, post-resolution implementation difficulties, some of which have been mentioned by the speakers, and we have, from various stakeholders, we get these feedback. Erosion of value of the corporate debtor before it comes to CIRP, that is a matter of concern. Here the timing and actually asset preservation is of real essence. Still, we see that the creditors have been able to recover more than 180% of the liquidation value of the corporate debtors, which have been resolved. This is the outcome. It is also seen that more than 30% of the companies which are resolved were not going concern. So this has also led to job creation in the economy. Under the, as we are all aware, and it has been various judgments of the Supreme Court, the commercial wisdom lies with the Committee of Creditors, as it provides for a competitive market-driven process of value discovery of a corporate debtor. It has been also stated in various landmark judgments of the Supreme Court that IBC process is not a recovery process. It is actually a reorganization. The recent decision of the Supreme Court upholding our notification operationalizing the provisions relating to insolvency resolution of personal guarantors to the corporate debtors will further help in increasing the recovery of the creditors. IBBI has been working on building the capacity of the committee of creditors through various seminars, and it is also addressing the market issues. It is also collaborating with IBA to instill ideal conduct among the members of committee of creditors. Aware of the what Mr. Sadhav Shah was stating on this issue, the licensor, that is RBI, has to play a very critical role. We are working with IBA, RBI, and the Department of Financial Services on this very important issue of conduct of committee of creditors. The insolvency professionals, some concerns have been raised, but IBBI being the regulator, it is conducting the regular inspections. Disciplinary proceedings are also initiated against such insolvency professionals who do not adhere to the law. In fact, we are creating a new cadre of young and trained insolvency professionals through the graduate insolvency program. Concerns have been raised about the NCLT. NCLAT infrastructure is being strengthened to address the delays in disposal of cases by filling up the vacant positions. We are leveraging technology by implementing the e-courts in all benches and organizing judicial colloquiums for capacity building of the members. Very important pillar for the IBC, the tribunals. Of course, the concerns of the market relating to implementation of the resolution plan due to claims raised by various government entities. It is also being addressed, as was stated by Mr. Kaushik Chatterjee, that more or less the central agencies, central government entities are now following the law, but our advocacy efforts, initiatives have been undertaken to sensitize the state government entities also, so that they are also made aware of these important changes in the law. We have amendments have been brought out in the IBC to make this resolution plan binding on all the stakeholders, including the government. The recent decision of the Supreme Court in the matter of Ghanshyam Mishra, which gives a clean slate to the resolved corporate debtor, which was also a concern which has been mentioned in respect of all claims, should address. This is a work in progress, and we will continue to. We are aware of this importance of this particular issue, and continue to make efforts to address this. We are for strengthening the code. As I have stated, we are constantly interacting with the academicians, with the policymakers, researchers, other stakeholders alike, for to make it more comprehensive and broad-based. That is our concern, and to address all the concerns of the stakeholders, so that we have enhanced ease of exit, and also we free up the stuck-up resources for other productive activities. We'll continue to work together to make this insolvency framework more effective and efficient. It will surely be one of the most important chapters in the success story of India becoming a 5 trillion economy. So look forward to interacting with all of you. We look forward to your suggestions. The way forward will come as we work together. I think we should be able to evolve a much more effective and efficient insolvency framework. Thank you.
Thank you. Thank you very much. Thank you very much, Shri Verma. Thank you very much for that wonderful presentation that you have given today. It's really, really very reassuring, and we really admire and we respect the consultative process that you and your government has established. We have, of course, some specific recommendations for the IBC 2.0, and we shall share those with the MCA secretary very, very soon. We look forward to your inputs further. And at any point in time, if the MCA needs additional consultation, then the task force, which is led by Shardul, we would be really want to be available at even a short notice, Shri Verma, to provide any discussions or consultations as IPC 2.0 gets finalized. But we really do appreciate yours taking your time and at your level to give us this timeshare and discuss with the industry. CII has one unique ability is to bring industry, the legal luminaries, as you've seen, and some of the insolvency professionals all on the same platform to provide inputs to our ministry. And therefore, the MCA might like to consider taking advantage of this, and we'd like your leadership, we'd like to work under your guidance and your leadership. And with the recovery from COVID having started, the pressure on the IBC institutions would be high. And as CII, we shall be ready to provide whatever support the MCA might need on this, please. So once again, Shri Verma, I would like to thank you on behalf of all our members of CII, 300 plus who are attending this important conference today and who have been listening to you, and also on behalf of my speakers in your session, particularly Shardul and Kaushik, for being able to interact with you. So thank you very much, Mr. Verma, for sparing your time once again on behalf of every one of us who are participating here. Thank you. Thank you very much.
Thank you. Thank you.
Thank you. Thank you very much. Thank you. Bye-bye. Bye-bye.